You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Electronic discovery, or e-discovery, refers to the process of identifying, collecting, reviewing, and producing electronically stored information, or ESI, for use in civil litigation. Modern lawsuits generate immense volumes of data, from emails and text messages to database entries and cloud documents. The Federal Rules of Civil Procedure provide the overarching structure for discovery, with Rule 26b(1) defining the scope. Discovery must cover information that is relevant, non-privileged, and proportional to the needs of the case. Proportionality considers the importance of issues, amount in controversy, access to information, and burden versus benefit of proposed discovery. For learners, proportionality is a guiding privacy principle. It ensures that discovery is not a blank check for unlimited access to personal data, but a calibrated inquiry designed to produce what is necessary without needless intrusion or excessive cost. The duty to preserve data arises once litigation is reasonably anticipated. At that point, organizations must suspend ordinary deletion practices and issue litigation holds to custodians and system administrators. A litigation hold is a formal instruction requiring individuals to retain relevant emails, files, or messages that might otherwise be overwritten or purged. Documentation of the hold, acknowledgement by custodians, and monitoring of compliance are critical for defensibility. For learners, this highlights the tension between privacy and preservation. Organizations normally minimize data retention to reduce risk, but litigation imposes an obligation to preserve potentially sensitive information until the matter is resolved. Governance must balance these conflicting imperatives by tailoring holds to specific custodians and systems, rather than freezing entire enterprise data flows unnecessarily. Identifying custodians, systems, and data sources is the next essential step. Custodians are the people who may hold relevant information, while systems include email servers, collaboration platforms, and databases where ESI resides. Data sources might extend to mobile devices, social media accounts, or shared drives. Mapping these sources ensures that discovery efforts are comprehensive without being wasteful. For learners, custodian and system identification illustrates how discovery intersects with privacy governance. Organizations must inventory where personal data exists, who controls it, and how it is accessed. This mirrors data mapping exercises required under privacy laws, showing that defensible discovery and privacy compliance share the same foundation: visibility into information assets and their custodians. Collection of data must be conducted using forensically sound methods that preserve integrity, minimize disruption, and avoid spoliation. Forensically sound means capturing information in a way that maintains metadata, prevents alteration, and ensures chain of custody. For example, imaging a hard drive or exporting emails using standard protocols ensures the data can later be authenticated in court. At the same time, the process must minimize business disruption, allowing employees to continue working. For learners, this dual mandate illustrates how discovery is both a legal and operational challenge. Technical rigor protects admissibility, while organizational sensitivity protects productivity and morale. Together, they show how legal obligations and business realities converge in e-discovery practice. After collection, data is typically processed to reduce volume, deduplicate, and preserve metadata. Deduplication removes redundant copies of emails or files, while metadata preservation ensures that details like timestamps, sender-recipient fields, and file paths remain intact for analysis and authentication. Processing also includes converting data into reviewable formats and filtering irrelevant information. For learners, this stage highlights the proportionality principle in practice. Processing is not just technical housekeeping. It is a governance exercise that ensures discovery remains focused and efficient. By reducing volume and eliminating noise, organizations can cut costs, reduce privacy exposure, and present a defensible narrative that discovery was pursued with discipline rather than indiscriminate data dumps. Search protocols are designed to identify relevant content within massive datasets. Techniques include keyword searches, concept searches that capture related terms, and technology-assisted review, TAR, using machine learning to prioritize likely relevant documents. Courts often encourage parties to cooperate in designing search protocols, ensuring fairness and efficiency. For learners, search design demonstrates the intersection of law, technology, and judgment. Keywords may capture obvious hits but miss nuances. TAR can improve accuracy but requires transparency about methodology. Search protocols reflect proportionality, broad enough to capture necessary evidence, narrow enough to avoid phishing expeditions, and unnecessary exposure of sensitive personal data. This balancing act is central to both privacy protection and defensibility. Privilege detection is another critical dimension. Attorney-client communications and attorney work product are privileged and must be withheld from production. Organizations generate privilege logs describing documents withheld and the basis for privilege. Federal Rule of Evidence 502 further allows for clawback agreements, enabling parties to retrieve inadvertently produced privileged materials without waiving protection. For learners, privilege management highlights the complexity of e-discovery. Privileged documents often contain highly sensitive data, so detection and logging must be meticulous. Clawback agreements act as safety valves, recognizing the impossibility of perfection in high-volume discovery. These tools reflect how law adapts to realities of modern data management, preserving confidentiality while enabling practical workflows. Protective orders and confidentiality stipulations provide added safeguards for sensitive personal data during discovery. Courts may issue orders limiting access to, quote, attorneys, eyes only, sealing records, or restricting dissemination. These measures are essential when discovery involves trade secrets, medical records, or financial details. For learners, protective orders demonstrate how privacy values are built into discovery procedures. They acknowledge that some data, though relevant, carries risks if exposed too broadly. Confidentiality mechanisms allow discovery to proceed without inflicting collateral harm, reinforcing that privacy and transparency can coexist when legal process is accompanied by protective scaffolding. Pseudonymization and redaction strategies further minimize exposure. Personally identifiable information may be masked or replaced with unique identifiers so analysis can proceed without unnecessary disclosure. Redaction removes sensitive fields such as social security numbers or addresses before production. For learners, these strategies illustrate how data minimization principles translate into litigation contexts. Just as privacy laws require minimization in commercial data processing, discovery law expects minimization in compelled disclosures. By limiting visibility to what is necessary, organizations protect individuals while still fulfilling legal duties. These practices reflect the operationalization of privacy law inside the adversarial process of civil litigation. Secure transfer, hosted review environments, and audit trail requirements complete the chain of custody. Productions are often delivered through encrypted channels or hosted on secure platforms with role-based access controls. Audit logs track who accessed what documents and when, ensuring accountability. For learners, this infrastructure demonstrates how cybersecurity underpins privacy in litigation. Without secure handling, sensitive data could leak or be misused, undermining both privacy and case integrity. Chain of custody discipline ensures that courts and parties can trust the data's authenticity, while access controls and logging enforce accountability. This stage reinforces that privacy protection does not end at collection but extends throughout the discovery lifecycle. Third-party vendor management is a recurring issue in e-discovery. Organizations often rely on specialized providers for hosting, processing, or review. Contracts must include privacy and security requirements, such as encryption, breach notification, and restrictions on subcontracting. For learners, vendor oversight illustrates how privacy governance extends beyond organizational boundaries. Discovery obligations may be fulfilled through third parties, but accountability remains with the producing party. Ensuring that vendors meet statutory and contractual standards is both a legal necessity and a privacy safeguard. This mirrors broader privacy frameworks like GDPR, where controllers remain responsible for processors' conduct. The parallel reinforces the universality of vendor governance as a privacy principle. E-discovery often raises questions of cost, especially when datasets are massive. Rule 26(b)(1) and related provisions allow parties to argue for cost shifting when burdens are disproportionate to benefits. Metrics, affidavits, and sampling are often used to support proportionality arguments. For learners, cost shifting illustrates how privacy and economics intersect. Large-scale production not only increases expense but also expands exposure of personal data. By limiting scope or shifting costs, courts encourage parties to be precise and disciplined. Cost-shifting arguments reinforce that discovery is not simply about producing everything available, but about producing what is necessary in a way that balances fairness, burden, and privacy. Post-matter data disposition is another crucial safeguard. Once litigation ends, parties must either destroy or return data produced during discovery. Certificates of destruction or documented verification assure compliance. For learners, this stage emphasizes lifecycle governance. Preservation obligations suspend deletion during litigation, but once the duty lifts, minimization resumes. Returning or destroying sensitive data reduces long-term risk and demonstrates respect for privacy beyond the immediate needs of the case. This practice illustrates how discovery obligations coexist with broader privacy norms. Hold data when necessary, but never longer than justified. Finally, special handling is required for sensitive categories such as health, financial, biometric, or children's information. Courts may impose heightened confidentiality, stricter redaction, or limited access conditions for these records. For learners, these measures highlight how privacy is contextual. Not all data carries the same risk, and discovery governance must adapt accordingly. By calibrating safeguards to the sensitivity of information, e-discovery law mirrors privacy statutes that impose special protections for certain categories of data. This reinforces the principle that proportionality is not one-size-fits-all but a tailored practice aligned with both evidentiary needs and the potential for harm. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Cross-border discovery introduces one of the most complex tensions in civil litigation. U.S. courts often order the production of data stored abroad, while European Union and Swiss privacy regimes restrict the transfer of personal information without strict safeguards. The Hague Evidence Convention provides a mechanism for letters of request, but U.S. litigants often prefer direct discovery orders, leading to conflicts of law. For learners, this highlights how privacy in discovery is shaped by international comity and competing sovereignty claims. The challenge is not just legal, but operational. Companies must decide whether to risk sanctions for non-production in the U.S. or penalties under foreign privacy laws for overproduction. The solution often lies in negotiation, protective orders, and the use of mechanisms like standard contractual clauses, but the core lesson is that e-discovery is inseparable from global data protection frameworks. The Hague Evidence Convention remains a key framework for reconciling international discovery disputes. It allows courts in one signatory country to request evidence located in another through formal diplomatic channels, often overseen by a central authority. While slower than direct discovery orders, the Hague process respects sovereignty and ensures that local privacy safeguards are applied. For learners, this mechanism demonstrates how international law provides structured alternatives to unilateral compulsion. It illustrates the tension between speed and legitimacy. Litigants may prefer quick direct orders, but long-term stability depends on respecting cross-border rules. Understanding the Hague framework teaches that discovery is not merely about evidence. It is about respecting privacy expectations and international relationships that underpin data transfers in an interconnected world. Standard contractual clauses, or SCCs, have become a common compliance tool for transferring litigation data from Europe to the United States. These contractual frameworks impose obligations on the receiving party to apply European-level safeguards even after transfer. Transfer impact assessments, now common after the Schrems II decision, evaluate whether the legal environment in the destination country undermines those protections. For learners, this requirement highlights how privacy law intersects with discovery at a granular level. It is not enough to argue that litigation demands relevance. One must also assess whether international transfers compromise privacy rights. SCCs and impact assessments illustrate how compliance tools operationalize abstract legal requirements, ensuring that data flows remain defensible under both U.S. procedural rules and EU data protection frameworks. Domestic state privacy laws increasingly affect discovery scope and production practices. Statutes such as the California Consumer Privacy Act impose obligations around the handling of personal data that extend into litigation contexts. Redaction of government identifiers, special handling of geolocation records, and limits on the use of sensitive categories all reflect these state-level overlays. For learners, this shows how e-discovery is no longer governed solely by federal rules of civil procedure. State privacy laws add another layer of obligations that parties must respect, making litigation governance a multi-jurisdictional exercise. This patchwork forces legal teams to adopt harmonized protocols that meet the highest common denominator, ensuring that discovery outputs comply with both evidentiary needs and privacy statutes simultaneously. Government identifiers, such as Social Security numbers, as well as geolocation information, represent high-sensitivity fields that require additional safeguards during discovery. Courts often mandate redaction of identifiers or substitution with pseudonyms before production. Geolocation data, capable of revealing intimate patterns of life, may be restricted to time frames or areas directly relevant to the case. For learners, these safeguards highlight how privacy risk is contextual. Not all fields carry equal potential for misuse, and discovery protocols must reflect that reality. Protective measures ensure that evidentiary relevance is preserved while collateral privacy exposure is minimized, reinforcing the broader principle that proportionality requires tailoring, not uniform treatment of all personal data. Despite safeguards, inadvertent disclosures and data leakage remain risks during e-discovery. Incident response planning is therefore essential. Organizations must be prepared to detect unauthorized access, notify affected parties, and remediate exposure. For learners, this shows how cybersecurity and discovery governance converge. Discovery repositories, often large and sensitive, can become attractive targets for adversaries. Building incident response into e-discovery planning acknowledges that no process is fail-proof. It reinforces that accountability lies not only in prevention but also in the speed and transparency of response, echoing privacy law obligations for breach notification and remediation in broader contexts. Data minimization principles are increasingly applied to discovery requests. Parties may limit scope to narrower timeframes, smaller custodian sets, or reduced data fields, avoiding wholesale production of massive archives. Minimization demonstrates respect for proportionality, protecting privacy while reducing cost and burden. For learners, this principle illustrates the overlap between privacy governance and litigation efficiency. Less data means fewer review hours, lower costs, and fewer risks of exposing irrelevant personal information. Minimization therefore serves as a bridge between fairness, efficiency, and privacy protection, showing how different values converge in discovery practice when scoped thoughtfully and defensibly. Discovery now extends far beyond email into modern collaboration tools. Chat logs, threaded conversations, reactions, and even emojis can all become discoverable artifacts. These records provide context but also carry significant volumes of personal or informal content. For learners, this evolution demonstrates how discovery adapts to communication practices. Protecting privacy in this environment requires threading conversations to reduce duplication, carefully reviewing informal exchanges, and applying minimization where possible. It reflects how the line between personal and professional communications has blurred, making privacy-sensitive handling of collaborative exports essential for defensible and ethical litigation practice. Mobile devices, messaging apps, and ephemeral media add another layer of challenge. Collecting text messages, encrypted app data, or disappearing media requires specialized tools and often involves accessing personal as well as professional information. For learners, this demonstrates how discovery collides with individual privacy directly. Mobile devices are intimate repositories, and discovery protocols must balance relevance with strict minimization, redaction, and protective orders. The challenge lies not only in technical capture but in ensuring that the review process respects the privacy of custodians, whose devices may contain years of personal communications unrelated to the litigation at hand. Social media discovery presents yet another frontier. Posts, comments, and even private messages may be relevant, but authentication and admissibility are constant concerns. Screenshots alone are often insufficient. Metadata and platform records may be necessary to establish reliability. For learners, social media highlights the evidentiary and privacy challenges of 21st century discovery. The content is often personal, blending private and public spheres, requiring strict scope limitations and redaction. Authentication demands show how technology complicates law, proving authorship and context requires more than visible text. Social media teaches that discovery is not just about access, but about ensuring that evidence meets legal standards without unnecessarily exposing individuals. Structured data from databases, logs, and enterprise systems raises different challenges. Producing structured data often requires custom queries or exports, making minimization crucial. For learners, structured data illustrates how discovery demands both technical expertise and privacy sensitivity. Logs may include IP addresses, user credentials, or timestamps that reveal private behavior unrelated to the case. Producing only relevant fields and limiting timeframes operationalizes minimization principles. Structured discovery thus emphasizes how technical tailoring ensures that legal obligations are met without excessive privacy intrusion, showing the constant interplay between evidentiary relevance and personal data governance. Discovery obligations also extend to expert witnesses and consultants. Sharing sensitive data with experts requires confidentiality agreements, protective orders, and sometimes anonymization. For learners, this reflects how privacy protections must be embedded into every stage of litigation. Experts often need access to detailed datasets, but safeguards ensure that use is limited, access is controlled, and personal information is not repurposed. Coordination between counsel and experts demonstrates how privacy responsibilities extend beyond the courtroom to every participant in the litigation process, reinforcing that privacy is systemic rather than localized. Throughout productions, quality control and review throughput metrics play critical roles. Accuracy rates in privilege review, error detection, and completeness assessments provide defensibility and demonstrate proportionality. For learners, this highlights how privacy is supported by governance metrics. Producing too much risks privacy exposure, while producing too little risks sanctions. Metrics provide balance, ensuring that production is sufficient but not excessive. Quality control thus becomes a privacy safeguard, as well as a litigation necessity, showing that defensibility requires not only compliance with orders, but measurable proof of accuracy and proportional scope. Finally, governance roles and training align discovery practices with privacy obligations. Legal teams must work closely with IT and privacy officers to design processes, monitor compliance, and train staff. For learners, this demonstrates how e-discovery is a cross-disciplinary endeavor. Lawyers may understand evidentiary rules, but IT staff understand data systems, and privacy professionals ensure minimization. Governance harmonizes these perspectives, creating a defensible, ethical, and privacy-sensitive discovery program. Training ensures that theory becomes practice, equipping staff to recognize sensitive data and apply protective measures consistently. Governance roles therefore complete the life cycle, embedding privacy into discovery not as an afterthought, but as a central design principle. In conclusion, e-discovery in modern litigation is both a technical and privacy challenge. Cross-border restrictions, sensitive data categories, and evolving communication platforms all require careful minimization, protective orders, and governance frameworks. For learners, the synthesis is clear. Discovery is not a free-for-all, but a proportional, scoped, and safeguarded process. Privacy protection depends on lifecycle management, preservation when required, minimization whenever possible, and destruction when duties end. By embedding privacy principles into every stage, e-discovery becomes not only a tool of justice, but also a reflection of disciplined governance in the digital era. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.